Welcome to this webinar. I am Alexander Malon. I'm the chair of the French chapter of the Chartered Institute of Arbitrators, and I'm glad to invite you to this event, which is co-organized with the UAE branch of the Chartered Institute of Arbitrators, chaired by Irina Akulenka. Irina is with us now. I would like first to thank, of course, Irina for this co-organization, also the Paris Arbitration Week organization team. Also, I would like to thank Amel Maklouf, who got the idea of this joint webinar, as well as Zaina Obeid, who will give a few closing remarks. Well, thank you also to our panelists. Irina, I think you have a few words also on behalf of the UAE branch. So I'll leave you the floor.
Thank you, Alexander. I hope everyone can hear me well. First of all, welcome everyone. It's a pleasure to be here. Thank you so much for joining us today. Thank you to Alexander for doing all the heavy lifting with all the organizing. I know he said that I did some work, but that's not true. Alexander did most of it. So thank you so much. Thank you, of course, to Paris Arbitration Week for hosting us. Pleasure to be here, to see all of our attendees online. Now, before I go further with the opening remarks, of course, we are excited to be here from the UAE branch perspective. It's our first joint webinar, as Alexander mentioned, with the French chapter. So it's exciting times, and I hope many more to come in the future. For the idea of this webinar, I should very much thank Dr. Amel Maklouf, who I can see is online with us today as one of the attendees. Amel is a lawyer based in Paris, and I should say, as Alexander already mentioned, without her, I don't think the idea of this webinar would have been born to start with. She got in touch with me sometime late last year, and she was curious if the business arbitration scheme that is used by the Chartered Institute in the context of the UK can be implemented in the UAE. And I said, look, it sounds very exciting, but I'm afraid that perhaps not many of our members or the community, business community here in the UAE actually is aware of the scheme itself, the benefits it can offer, and what actually does it do. And then Amel suggested that she gets in touch with Louis, who is one of the panelists today. Louis is head of policy for CIArb based in London. So he will be talking about BAS, what we call business arbitration scheme in details later today. And that's how we started sort of talking and discussing the webinar and the idea of it. And I wanted from the start to keep the topic quite broad, as you can see from the title of the webinar itself, and talk about perhaps different things. We often organize events, at least in the UAE, aimed more at sort of arbitration and, disputes that are complex, that are multi-billion disputes, mainly construction industry related, etc., which is okay in the context of the UAE and the Middle East overall, I suppose. But we tend to sometimes ignore very important things, tools and various options that are available to the community in terms of actually preventing disputes, dealing with disputes in a more sort of amicable way, less adversarial way, whether it's mediation or mediation in the context of arbitration, which our panelists are going to touch upon today, multi-tier clauses, etc. So there is lots of things that are available for more speedy and affordable dispute resolution. And the last thing that I wanted to say before I introduce the moderator for today is I was very keen to get somebody on the panel who can talk about what's available for the SMEs and the smaller commercial entities in terms of perhaps more decentralized dispute resolution options and things like that. And I'm very pleased to say that after much research and interviewing a couple of people on the ground, I came to know Sandeep, who I should say I didn't know before this, but I'm very pleased that Sandeep is joining us today, and he's going to, at least he did open my mind about certain things. He's going to talk about all exciting things that are happening in decentralized sort of domain, and what arbitration can offer there. We should not definitely forget that there are smaller entities, there are smaller claims. Not every claim is a multi-billion claim, and I think it's important that we keep that in mind as dispute resolvers. And with that in mind, I should introduce Samantha Lord-Hill, who is the moderator for today. I've known Samantha for many years, since she's been based in the UAE. And I will just say a couple of words about her practice. So Samantha is counsel with International Arbitration Group in Freshfields. She is based across Dubai and London as well. Her practice focuses on commercial and construction disputes arising out of major projects worldwide, with particular emphasis on energy, natural resources, and infrastructure sectors as well. Samantha sits on the Global Advisory Board of ICDR Young and International, where we are colleagues again with Sam, and the MENA subcommittee of the Campaign for Greener Arbitrations. She is a member of the Chartered Institute of Arbitrators, International Bar Association, and Arbitral Women as well. She sits as arbitrator herself and is the co-author of the UAE chapter of the ICCA Handbook on International Commercial Arbitration, among other publications, of course. Samantha, the floor is yours.
Thanks so much, Irina and Alexandra, for your introductions today. I am delighted to moderate our panel discussion, which I'm sure will be incredibly interesting. But before we get to that, I would like to introduce our 4 distinguished panelists for today. First up, we have John Lowe. John is an arbitrator and mediator based in Paris and New York. He's served in over 40 arbitrations, both institutional and ad hoc, under a variety of rules. He's also an active mediator in France and the UK. And before doing this, he was a general counsel and in-house counsel for major international infrastructure, manufacturing and transportation companies, where he handled legal issues facing such companies. He began his career as a diplomat with the US Diplomatic Service, specializing in economic matters. We also have with us today Atina Fouchard-Papastratou, who is an independent arbitrator based in Paris. She's been repeatedly included in the 10 most highly regarded arbitration specialists, non-partners, in Europe, Africa, the Middle East by Who's Who Legal. Atina has a wide experience in disputes in telecommunications, energy and construction sectors, as well as in disputes involving states and state entities. She is a founding member and former co-head of CIARb, which is an association for professionals focusing on Africa-related arbitration. She's also a member of the ICC Commission on Arbitration and ADR, and a board member of the Arbitration Committee of ICC in Greece. And last but not least, and importantly for today's session, she is also a member of the Executive Committee of CIArb European Branch. Next up, we have Sandeep Balotia, who is a SCMA accredited mediation advocate and certified Islamic arbitrator and expert at the International Islamic Center for Reconciliation and Arbitration. Sandeep has been working as WIPO neutral arbitration and mediation, focusing on technology and domain name disputes. He is the head of legal affairs at Augmented Era, where he primarily focuses on technology, data protection, and dispute resolution advisory. He's also a dispute advisor and mediator with ODRI International, excuse me, which is a USA-based e-mediation platform. He has also worked with Clearos, a decentralized arbitration platform, as its law and policy fellow. He regularly publishes on technology, law, and mediation. Last but not least, we have Lewis Johnston, who is the Director of Policy and External Affairs at the Chartered Institute of Arbitrators based in London. Lewis leads CIArb's influencing program to promote all forms of alternative dispute resolution around the world, including, as Irina mentioned, the BAS program, which we'll talk about today. Working with partners and stakeholders, He and his team emphasise the transformative effect that ADR can have on outcomes for parties and the role it plays in underwriting economic prosperity. So, with those introductions underway, we're going to kick off today's session with our first topic, which is multi-tiered dispute resolution clauses. And the first panelist up today is John. John, in relation to multi-tiered dispute resolution clauses, can you tell us whether you've seen an increase in the use of multi-tiered DR clauses in recent years?
I realized I was muted. Now I am unmuted. Yes, Sam, thank you for getting this started. Yes, I've been working now as an arbitrator and mediator for about 6 or 7 years. Prior to this, I was a general counsel, and I would say it was only in the last 3 or 4 years of my work as a general counsel that we as a company really started incorporating multi-tiered dispute resolution clauses into our agreements. These basically provide that there will be negotiations, then probably mediation, and that has to all happen before the companies can go to arbitration or litigation. And I think what I am seeing now, I still talk regularly with my colleagues who work as general counsel and in-house counsel, and they are telling me that they are using multi-tiered clauses on a much more regular basis for this. There's probably a number of reasons for this. There's a lot more information available about what they are and how they are written. Draft multi-tiered clauses are readily available on the sites of all major arbitration institutions. And companies are paying always an increasing greater deal of attention to reducing costs and times of the disputes. Finally, I should also say that courts and national legislatures are starting to give mediation in particular, but alternative dispute resolution more generally a big push. Many of you will be familiar with the Queen Mary surveys of international arbitration. In 2021, they actually did a survey asking their respondents what they look for in what they prefer in dispute resolution. And an astounding 59% said they prefer multi-tier dispute resolution clauses, mostly with ADR and arbitration, although about 6% also preferred litigation and arbitration, litigation and ADR, which means that 65% preferred a multi-tier dispute resolution system in their contracts. For comparison purposes, the Queen Mary's had done a similar a survey in 2018, and in that survey, the number was only 49% who were using multi-tier dispute resolution clauses. So we see that there has been a very marked increase, and I imagine that this is going to continue. One thing I would say about multi-tier dispute resolution clauses, I mentioned that they typically provide for negotiations, then mediation, and then arbitration and or litigation. In my experience, from a practical point of view, it's having the mediation at the beginning of the dispute when arbitration occurs or is not always the best time. That being said, from a drafting point of view, it certainly is the easiest and frankly the most practical way to draft a multi-tiered dispute resolution clause.
Thanks very much, John. Just picking up on that last point you made in relation to the timing of mediation. Your experience is consistent with mine in that mediation is normally one of the first steps before you eventually get to arbitration. But I agree that's not necessarily always the best time to actually mediate a dispute. In your experience, why is that? And do you have any views on whether if parties do mediate at that early stage and a solution isn't reached, whether that's seen as like a wasted effort on both sides?
Okay, thanks, Sam. Let me deal with both of those questions. First of all, my experience shows that once parties get involved in a litigation or arbitration and they see that the other side's position is not as weak as they originally thought it was, they see that it's going to be expensive, it's going to take time. And an important factor is that senior management time is going to have to be devoted to this litigation or arbitration. That's when they start thinking much more seriously about settlement or arbitration. And that's settlement or mediation. And that's frankly when those settlement or mediation talks can be most effective. That being said, if parties start with a mediation and it doesn't work out, they will have at least laid the groundwork for potentially a future mediation. Actually, last year I had a very big corporate M&A dispute going on. The parties had actually tried mediation at the beginning of the dispute, but going into the dispute, and frankly, right before the hearing, they actually went into mediation again and were able to come up with a solution. I think it partly helped that during the discovery process and the preliminary of the arbitration, there was more clarity on issues of liability and damage, but it also shows that having started with a mediation, the parties keep in the back of their minds that they're able to mediate and that they can always go back to it. So that is one possibility. And let me also, going to your second point about whether or not a mediation that is not successful, whether it's a waste of time and effort, I think I've already answered that with my first example. But I also had another mediation very recently where there were about 5 or 6 issues on the table. During the mediation, the parties did not reach a settlement. However, they actually realized that there was only one issue that really mattered to them. And frankly, all the others were background noises. So mediation, even if it's not successful, can either lay the groundwork for further mediation or at least clarify the issues for the party. I wanted to say a few words about the fact that courts and national legislatures are also pushing mediation. Here in France, there's actually a new law. It's actually something called law number 2021-1729 from December 22nd, 2021, which envisaged the creation of a national mediation council. And this is actually the implementing decrees are currently being discussed and reviewed by the French legislature. I would also say that we are now seeing in French courts a push to have the parties, at least in some instances, mediate before they're able to go further with the litigation process. This doesn't mean they have to mediate. The way it is being handled by the French courts is that they ask the parties to have an initial discussion with the mediator, probably for about an hour or so, where mediation is explained. And then it's up to the parties whether or not they want to proceed with the mediation. I actually experienced this a couple of weeks ago where the parties did hear me speak about the benefits of mediation. They decided to go ahead with the mediation. Unfortunately, they did not settle, but they were very close. And frankly, either one of them could make one more move and the issue would be resolved. So we'll see where that goes. I also wanted to say that one of the reasons multi-tiered dispute resolution is growing in popularity is because in-house counsel and general counsel are starting to hear from their colleagues that actually alternative dispute resolution may work. One of my favorite examples is Areva, which is a French nuclear manufacturer of nuclear plants, had an enormous arbitration going on with the Finnish national energy company, which eating up time and money. And finally, after about 6 or 7 years of this, they were finally able to resolve their dispute through mediation. And again, keeping down costs and times associated with litigation and dispute resolution is always key. And companies are realizing that alternative dispute resolution may work. I want to spend a couple final minutes talking about what I see as a movement by international arbitration institutions to accommodate and to almost and to really support mediation and alternative dispute resolution. For many years, the arbitration institutions viewed themselves as purveyors of arbitration services only. That has changed dramatically in the last few years. Let me take give you two examples. The ICDR, which is the international arm of the American arbitration, recently changed their rules in 2021. There is now a presumption that the parties will mediate under the mediation rules concurrently with the arbitrations. The parties can opt out of this, and that's Article 6 of the rules, but the presumption is that they will mediate either before or during the arbitration. And when they're filing the notice of arbitration and responding to that notice, they are required to state that they are willing to mediate the dispute prior to or concurrently with the arbitration. Let me also make one other, give you one more example. The ICC also changed their rules in 2021. They were somewhat less aggressive, but they are still mediation friendly. Under their new rules, tribunals are invited to encourage parties to consider settlement. This is Article 22, Section 2, and Appendix 4. For example, tribunals may inform parties about the ICC mediation rules and the benefits of mediation, or to suggest that settlement negotiations are appropriate. Arbitrators, counsel, mediators, they are all starting to understand and trying to understand how this actually might work in practice.
John, just on that note, you've mentioned the ICC rules as an example, which probably give arbitrators a little bit more freedom or discretion, if you like, in terms of how they propose mediation or how they go about trying to wrap it within the context of their arbitrator role. As an arbitrator yourself, do you have any sort of hints or tips for other tribunal members as to things they might want to consider before making a suggestion for the parties to try to mediate? And if they do make that suggestion, how do you think they should go about doing that?
It's a good question, and one that I think all arbitrators should be struggling with right now. A few years ago, I thought my role was simply to be an arbitrator and to decide cases. Now I am moving in the direction that if there's an appropriate time, if I see that the parties are not that far apart, I think it is appropriate to suggest mediation. I actually find it easier to do this in an oral setting. So either generally not at a preliminary hearing because that's too early, but maybe as you're doing an interim hearing or maybe in preparation for the final hearing, that is a time when it could be raised. I will say that there is an issue. It's probably easier for a sole arbitrator to do it because then it's her or his decision. If you're on a panel, then I think you need to make sure that all the arbitrators are in agreement before you make that suggestion. You don't want disagreement among the panel. The panel needs to be in unity. But let me just make a final remark on this point, is that I think as arbitrators, we now need to think about our role not only is deciding a case, but also making sure the case is being handled efficiently and effectively, and that may require or may lead us to suggesting that the parties engage in settlement negotiations or that they try mediation. Again, it's a suggestion, but I think we need to be much more open to that idea than we may have been in the past. And I'll stop there, Samantha. If you have any further questions, let me know, but I know we're on a tight schedule.
We are on a tight schedule, and without wishing to blow that schedule out myself after making sure you all stick to time, we have one interesting question that has come through from the audience from Thomas Kelly, and I just wanted to pick up on part of that question, which is around what is the effectiveness of multi-tier dispute resolution clauses if one of the parties doesn't want to take responsibility for a settlement and would rather have a third party, i.e. an arbitrator, actually impose a decision on them rather than somebody within the company or within the state, a state entity, actually taking responsibility for the outcome of that dispute. Have you come across that scenario, and do you have any?
Well, I haven't come across that scenario personally, but I do have a couple of friends and colleagues who are trying to introduce the idea of mediation into investor-state arbitration. And I have heard that in investor-state arbitration, it is politically much more palatable for the state, particularly, to leave the decision to an arbitral tribunal rather than to have mediation. That being said, there is a strong effort underway even to bring mediation into the investor-state world. Again, if the parties do not want to mediate or they do not want to talk settlement, nobody can force them. But I think what is happening right now, what I see is that there are people, there are mediators, there are arbitrators who are starting to talk about the benefits. And as we've seen with commercial arbitration, there's a lot more willingness to engage in mediation. I think there will be a time when even in the investor state area, we will see that mediation is starting to become much more acceptable.
Yeah. Thanks, John. I think that's really valuable insight. That's consistent with my experience, where even in commercial context, entities which ordinarily wouldn't necessarily want to take a decision for the purposes of a mediation and would traditionally prefer to rely on an arbitrator's decision are still including the likes of mediation in their multi-tiered DR clauses, but perhaps making it optional rather than a mandatory step, so they can use it depending on the type of dispute. In addition to multi-tiered dispute resolution clauses, providing, as John has spoken about, pre-arbitral steps such as mediation, negotiations, etc., we've obviously all seen arbitral institutions taking steps to try to provide for quicker resolution of disputes that are ultimately referred to arbitration, largely as a result of criticisms in recent years that arbitration is becoming too lengthy, too costly, and too much like a court proceeding. Atina, if we hand over to you next, can you tell us a little bit about expedited or fast-track arbitration?
Yes, thank you very much. And I would like to start by referring to the Queen Mary and White and Case survey that John mentioned earlier on, and it's quite, I quite like it also because Queen Mary has been my alma mater. And the importance that this survey had for the arbitration market. So going back to the 2015, that survey in that year revealed that one of the main criticisms against arbitration was the lack of speed. And arbitration institutions reacted quite swiftly by developing either separate sets of rules for expedited arbitrations. That was the case of the Stockholm Chamber of Commerce, the CIArb 2018 rules, or the very recent ancestral expedited rules, or, as did the ICC, by inserting provisions for expedited arbitrations in their ordinary, in the normal rules. So what is expedited arbitration or fast-track arbitration? It is a simplified form of arbitration proceedings with shortened time limits. And it brings, and that's its importance, time efficiency, and also, given that time is money, right, cost efficiency in arbitration. What are its typical characteristics? Usually there is a sole arbitrator appointed within a shortened time limit. And it is noteworthy in that respect that under three, actually, I think, sets of arbitration rules, the ICC rules, the Singapore and the prime finance rules, even when the arbitration clause provides for a 3-member panel, if expedited proceedings take place, the institution will appoint a sole arbitrator to handle the dispute. So one typical characteristic is that. Then expedited arbitrations have shortened time limits. Shortened time limit for the holding of the first procedural hearing, the case management conference. Shortened time limit for the issuance of the award, which, for example, under the CIArb or the ICC rules, it has to be issued within 6 months from the case management conference, or under the arbitral rules or the the Singapore rules, it has to be issued within 6 months from the appointment of the arbitral tribunal. Other rules provide for limits to the number and the length of the submissions, and also provide for the possibility of the arbitrator not to hold an oral hearing. And I open a parenthesis here. There are certain rules which provide that. This is the case of the ICC rules, the Stockholm Chamber of Commerce, the Hong Kong rules, the Singapore rules. But there are also other rules which follow in that regard a more traditional approach, according to which if one of the parties requires a hearing and requests so, then a hearing has to take place. So that was a short presentation of expedited, the common characteristics of expedited arbitration.
Thanks very much, Athena. For those in the audience who are perhaps in-house counsel at companies considering expedited arbitration, what do they need to do to actually have their disputes resolved by expedited arbitration proceedings?
Most of the arbitration rules provide that an expedited arbitration proceeding will apply either when the parties so request, or provide that the expedited rules will apply automatically if the amount in dispute is below a certain ceiling. So either the parties have agreed in their contracts that expedited arbitration will apply either for all of their disputes or disputes under a specific threshold, or once the dispute arises, the parties agree that they would submit this dispute to an expedited arbitration proceedings, or depending on the amount in dispute, there will be an automatic application unless the parties have specifically opted out of it. And just to give you a couple of examples from the arbitration rules, the ICC, for example, provide for automatic application of the expedited rules if the amount in dispute is below 3 million USD. But they also provide for the possibility of the parties to opt in, to agree upon the application of the expedited rules, no matter what the amount of in dispute is. This is the system that is also followed by CIArb. Other sets of rules, like the Vienna Center or the arbitral rules, on the other hand, provide for expedited arbitration, but only as an opt-in method. So the parties have to agree for this procedure to apply. I hope I answered in-house counsel and other interested parties.
You certainly did. That was really helpful. Understanding that you're now practicing as a full-time arbitrator, for which we should say congratulations. Do you have any hints or tips for other arbitrators on how to effectively and efficiently manage expedited proceedings, appreciating the fact that they're supposed to be in and of themselves kind of efficient and effective anyway?
What you just mentioned is extremely important. From my experience, what I find most important is that the parties understand right at the outset of the procedure that having an award in, say, 6 months requires a common effort by the arbitrator and by the parties. Parties have to understand that measures such as limiting the length of the pleadings, which I find particularly important, or very limited document production possibility, or limiting the hearing to specific issues are necessary in order to have the wanted result, the award within a very short time. Another aspect that I find particularly useful is allowing for a certain degree of creativity in the way that written submissions will be made. In one of my recent cases as arbitrator in expedited proceedings, the parties submitted each 2 pleadings, 2 written pleadings, and for the rejoinder and the surrejoinder, instead of submitting again separate sets of pleadings, they only inserted comments on the written pleadings of the other side, which were filed both in PDF and Word format. And a similar possibility would be that up to a certain degree, arguments can be exchanged in a table format. What else? Yeah, and I find particularly something that I do not only in expedited arbitrations is to send in advance of the oral hearing questions on which I would like the parties to focus. The parties are free to focus on other subjects, but in that way I manage to keep the hearings on the point and make sure that they are useful and they are efficient. So yes, these are tips, and the important axis that one has to keep in mind is that parties should be given a full opportunity to present their cases, but within the limits of reasonableness.
That's really interesting. I've never come across a party just commenting or marking up somebody else's submission. I think that's a really interesting idea. Would definitely save a lot of time for counsel. I wanted to pick up, Atina, before we move on one of the questions that has come from the participants, from Olga Kuprenkova, which is, what are your thoughts on expedited arbitration proceedings for investment disputes?
May I just be honest here? I think that this might be an overstretch, given the extremely important issues that are at stake in investment arbitrations, given the public interest in the disputes. I don't think that investment arbitration is a particularly good place for expedited proceedings to take part. An issue that is of relevance in investment arbitration proceedings, though, and if we have time to discuss on it, it would be good, is the possibility to proceed to summary proceedings, to proceed to an early disposition of issues, which can also apply in investment arbitration.
Yeah, I think it would be really helpful if we moved on to talk about that now, because it's something that, at least in my experience, is gaining popularity. So either through parties proposing summary disposition of one issue or more issues, or arbitrators sort of trying to push for parties to identify issues to be dealt with early on. What is your experience in this regard?
I find that early disposition of issues in arbitration is a very useful tool, especially in complex disputes, because it allows the issues in dispute to be simplified, and it allows for a huge gain in terms of time and in terms of money. On the other hand, and it is important to note that the question of early disposition of issues kind of exemplifies the tension between the need of efficiency on the one hand and the need to ascertain each party's right to present its case on the other hand. Of course, the right to present one's case is not limited. It's not unlimited. Arbitration proceedings cannot last forever. And arbitration should not allow lengthy exchanges on meritless claims brought only to delay proceedings, right? But on the other hand, the arbitrator should make sure that early disposition of an issue does not risk amounting to a violation of a party's right to a fair trial, especially given that an appeal against an arbitration award is not possible, a possibility that is offered for court cases. And the decision of the arbitrator is subject to only very limited review. In practice, arbitrators should make and actually make restrictive use of the possibility. We proceed to the early dismissal of a claim, for example, if it is manifestly outside our jurisdiction, if it is inadmissible, manifestly inadmissible, or manifestly without merit. And perhaps to give a quick example in that regard, as an arbitrator, I would accept to hear an issue and at the end of the day dismiss a claim early in the proceedings if I consider that it is possible to conclude whether it lacks or not legal basis without assessing whether the facts that the claiming party has alleged in that regard are true or not. I can see the interest of early dismissal or early disposition when it comes, for example, to questions about time limits or to questions of admissibility and jurisdiction.
Thanks very much, Athena. One last question before we move on. Do you have, again, any hints or tips for other arbitrators out there who may be grappling with early dismissal issues or whether to deal with something on a summary disposition basis? Do you have any hints and tips as to how to go about that or other factors other than due process that they might want to consider?
Yes. One preliminary tip is check the rules under which you operate, because right now there are certain sets of rules which specifically provide for such a possibility of an arbitrator. And for the time being, they are limited. This may happen. The trend is towards embracing this possibility of an arbitrator. And also, arguably, even if the rules do not provide for such a possibility, it is somehow within the power of the arbitration or the arbitrator, the discretion of the arbitrator to run the proceedings. But we have to be conscious that different rules apply different things, provide for different things, and different laws also provide for different solutions on that. And then when it comes to more practical tips, I would say that when faced with an application with such an application for an early disposition, the arbitrator should ask the requesting party to set forth at the outset, first, how the disposition of the issue will advance the efficient resolution of the dispute, and two, what is the procedure that the party suggests to follow for the early determination? And of course, ask the other party's views on the same. Why is this important? Because an arbitrator should avoid finding themselves in a situation where the issue appears to be complicated and it is intrinsically linked to other disputed issues, or in a situation where the proceedings for the early determination actually will last quite some time. And I think that asking these two questions at the outset will allow the arbitrator to have a better view as to what is the proper way to proceed, to allow or not to allow for such an early determination.
Thanks so much, Athena. As between John and Athena already today, you've both given us some insights into the ways in which what I call traditional dispute resolution mechanisms are sort of adapting to the changing needs of businesses in order to deliver faster and more efficient dispute resolution processes. We're also seeing relatively new and innovative processes developing and becoming more popular. So at this point, I'd like to give the floor to Sandeep to discuss with us why you think discussions around online dispute resolution, decentralized arbitration, and innovation in arbitration more generally are obviously happening more frequently and are important to businesses around the world.
Sure, Sam, thank you so much. In the last couple of years, we have seen very significant advancement in the technology. We have seen more powerful smartphones. We have seen enhanced internet connectivity, even in the remotest part of the world. And we have also seen some new technologies coming into picture, whether it's blockchain, NFT, or cryptocurrencies and associated economy around it. Now, what it has done is it has somehow directly or indirectly impacted the dispute resolution process, because it has created unique requirements and unique challenges. And online dispute resolution process used to be a novel thing, say 20, 30 years ago, when people were still building up and discussing about it. But especially in the last 3 years, a lot of significant changes have taken place. Firstly, because of these technology, and the second, because of the COVID. We have seen some of the leading arbitration institutes providing online platforms. We have seen new mediation and arbitration institutes coming up to provide these kind of services at a cheaper cost, taking less time, and increasing the simplicity and efficiency of the process in general. And these technological advancement has basically impacted the demand for ADR in two ways. There are two important factors that are very important for our discussion. The first is that because of these technological advancement, and when I'm saying technological advances, I'm specifically speaking about, say, blockchain and the economy around it, and the new economy that has been created around it, and the digital transactions that are taking place online because of it. On a daily basis, millions of dollars are exchanged on various platforms for the purchase of products and services, right? And as per the latest report of McKinsey, out of all these transactions annually, 1% of those transactions goes to the dispute. Now, from outside, 1% might seem very low, but 1% constitutes billions of dollars, because think about how many people on daily basis are purchasing products and services online as an individual customers, not as a sophisticated parties or companies. And if you take this 1%, the number of transactions are really huge. Per transaction, dispute amount could be really low, could be 100 USD, 200 USD, but the number of transactions that are taking place are a lot. And if those transactions are going into some sort of dispute, then the next logical move would be the resolution of those disputes, whether you go through the litigation, mediation, arbitration, or whatever form you want to put those disputes through, you have to somehow find a resolution to those kind of disputes. And that's where I think the ODR has gained the momentum, or say the decentralized arbitration, which I'll be speaking in depth, has gained the momentum, because on one side you have more economy and business that is growing around digital transactions, and more small scale disputes taking place, which does need resolution. On the other hand, the existing dispute resolution mechanisms, whether it's an traditional arbitration or litigation, is not suitable for resolution of these kind of small scale disputes. And that's where the push, and that's where the demand for the ODR and discussion around are happening, because a lot of governments have made certain policies, a lot of institutes have adopted it, a lot of scholars have written about it, and there's a lot of discussion happening around it to serve those kind of business needs.
Yeah. You've mentioned, Sandeep, that obviously ODR, or online dispute resolution, is no longer a novel thing, and it's sort of exploded, if you like, over the last few years. Where does what we've called decentralized arbitration fall into this equation? Can you give us an overview of what it is, who its users are, and what some of the advantages or perhaps disadvantages as well might be? Yeah.
Before we get into, say, decentralized arbitration, from the outside, it might look like a form of online dispute resolution mechanism, but let's speak about what ODR is and how it has impacted a dispute resolution mechanism. My understanding is that ODR has not specifically made a significant dent in dispute resolution mechanism, because if you look at it, it has kind of taken the existing in-person experience on a digital sphere. It has obviously in that process reduced the cost, reduced the time, increased the efficiency, and kind of bridged that digital justice gap between the parties. But still in the dispute resolution process, you have three main stakeholders. If a two-party dispute, then there are two parties and the arbitrator and the mediator. And you've just taken that on a platform where, you know, in the initial phases of online dispute resolution, ODR mechanism, parties used to exchange emails to submit, you know, their submissions and provide arguments, attach files to it. And then the early phase of, say, during the COVID era, when things started moving online, you will see on one hand, they are exchanging emails as a part of ODR, but the hearings are done on Zoom calls. So it's still not an integrated. And slowly then we saw a lot of parties, a lot of companies and a lot of stakeholders coming up and trying to integrate this entire setup of dispute resolution in one platform where, you know, on the same platform, you can exchange the documents in an encrypted way. You can also have chat mechanisms where you can chat with the parties and the arbitrator. On the same platform, you can appoint the arbitrators, you can challenge the appointment, you can provide different kinds of submissions that you need to. And also there is the same platform where you can initiate the virtual hearing. But still there are three major players within the dispute resolution process. And what decentralized arbitration has done basically is introduce the fourth player in the entire process, because decentralized arbitration is basically a platform where, to oversimplify it because of the limitation of the time, where the arbitrators, for that matter, various and decentralized arbitration platforms, call them jurors, are selected anonymously. Their identity is not revealed. So in a traditional arbitration, you see, you will know who the arbitrator is, but in decentralized arbitration, you don't have the identity of the arbitrator. You only know their public wallet address, cryptocurrency or token address, or an alphanumeric key. That is the identity of an arbitrator. And the second thing is, an arbitrator wouldn't know who the other arbitrator on the panel is because their identity is also hidden. So how the existing arbitration and mediation platform work is, they are basically on moral and ethical requirements where a judge, an arbitrator, or a mediator is expected to behave in a certain way, is supposed to be impartial, have independence and, you know, lack of partiality for the parties. But when we shift it to decentralized arbitration, there are certain things that are presumed because you don't know the identity of the parties. That is also in alphanumeric key. Numbers and important identities of the parties are hidden. Only the specific issues are provided. Now, I'm not saying it's suitable for all kind of disputes, but that's how it's happening in the decentralized arbitration. And you also don't know who the other arbitrator is. So the entire decentralized arbitration platform works around the game theory. And if you go back into cryptoeconomics and everything, we'll understand what exactly the game theory is. Is basically, if you do the right thing, you will be rewarded. So if you have a dispute in front of you, you don't know what other two arbitrators are going to decide. You have to just focus on yours. You don't know the identity of the parties. And the only way for you to earn incentive is to provide a decision which probably out of three arbitrators, other one arbitrator will also give the same decision. And if the decision is same, then you will be incentivized. And if you are the odd one out, you will not receive any kind of benefit. So you will tend to do is presume that you will do something right. You will try to give the right answer. And this is the logic behind which decentralized arbitration works. So I think that is kind of a phenomenal change in how we look at dispute resolution and how we have been looking at the dispute resolution platform so far, and how we have been looking at arbitrator and mediator and how they behave so far. So that is a drastic change. And when we speak about decentralized arbitration, the earlier use of decentralized arbitration was around smart contracts. No, what is smart contracts? To oversimplify it again, it's just a program code which kind of provides if and then analysis, which basically means if situation A happens, the code will give result B. So say suppose there is some transaction taking place on a platform, and if party A receives the transaction, the computer will automatically send signal to an online wallet to release the funds. So there is no intervention of third party. There is no intervention of a central bank or the party cannot say no to certain transaction. They have to go through that transaction. So those are the smart contracts. So the initial use of decentralized arbitration was around these more objective disputes where the outcome would be 0 or 1, more binary, where it's more based on the software. But now we have seen a decentralized arbitration also being used in more subjective disputes, because we as a lawyer, when we draft contracts, we know that it doesn't matter how diligent we are, there are going to be mistakes. There's a possibility of mistakes in drafting an arbitration agreement or any kind of contract in general. And most of these disputes are because of those mistakes, the lack of clarity, the lack of understanding between the parties, what they expected, and those kind of errors. Same happens in a computer code. You have your mobile application that need constant update because there is a bug. There is an error in their coding which needs to be updated and rectified. And if there is an error in a smart contract, that means there is a dispute which needs to be resolved. So as long as smart contract related mobile application or any transaction that is happening sits on a completely decentralized platform, you will immediately have a response who is right and who is wrong. And in certain cases, in decentralized arbitration, the judgment comes or the award comes within a day or two, because it's a very niche area with a lot of use of the technological transactions and data and documentation rather than more of an sophisticated oral arguments. And that's the market usually we see for the decentralized arbitration. But having said that, there are a couple of leading decentralized arbitration platforms that have resolved a lot of hundreds of disputes since 2017 when these platforms started. One of the leading and I think the first movers in the decentralized arbitration domain is based out of France, Claros. It started in 2017, and it is one of the leading, I would say, decentralized arbitration platform. And it went on the Ethereum blockchain, and I won't speak about those technicalities. In 2018, we have limited time. And the second one is Aragon, which again started in 2017. It's based out of Switzerland. The third one is Jur, again started in 2017, based out of Switzerland. So what these platforms do is they kind of provide resolution of the disputes both on the objective, smart contracts, highly technical, those kind of disputes, as well as subject, the kind of disputes that we see on day-to-day basis. And the reason why, again, as you asked, who are the users of it? Obviously, blockchain-based mobile applications, digital transactions are the primary users of it. But now we have started seeing their use in more of real-life scenarios as well. And I'll speak about that as well. But first, I will focus on the primary users. There is
Sandeep, I'm sorry to interrupt you, but just conscious of time, once we've just covered off on the user's point, there's one burning question that as a traditional arbitration practitioner I have, and I'm sure others in the audience have as well, which is whether there are limitations on the enforceability of awards that come out of these decentralized arbitration procedures. So if you cover off on the user's point and then address that, I at least would be really grateful and interested.
Sure. There are definitely limitations, and I will come to that as well. And there are certain, I would say, positive movements that have also happened when it comes to the enforceability, and we'll check on one of the judgment delivered by the Mexican Supreme Court on those lines as well, recognizing a first ever record of recognizing a decentralized arbitration award. Coming on, say, the use cases, obviously, on one hand, we have these more traditional blockchain-based digital platforms which are using it, whether it is for the transaction of selling a source code or a domain name. But we have also seen in the last 2 years discussions around metaverse, right? Especially around Facebook renaming itself as Meta, and then a lot of discussions going around metaverse, augmented reality. In metaverse, if we been following it, we know that all the assets are digital. You have a digital home, you have a digital bike, you have digital assets, you have school, and a lot of different things. And people are trying to invest a lot of money in the metaverse itself. And that is also going to be one of the primary users of these platforms. Coming to the limitations, there is obviously a limitation, but before that, I will just walk you through one of the recent judgment of the Mexican Supreme Court, where they recognized decentralized arbitration. So in that specific transaction, there were two parties which entered into an agreement for the leasing of a real estate property. And there was some dispute with respect to the payment of rent and payment of the consideration in that. And the arbitration clause in that contract provided for a decentralized arbitration. It stated that if there is any dispute, then the parties can approach the appointed arbitrator. And once the arbitrator is approached, they can frame the procedural order if the claim is established and refer it to the Claros platform for decentralized arbitration. And once the protocol gives you the judgment, protocol gives you the answer who's right and wrong, the arbitrator can incorporate that and provide its judgment, its arbitration award on top of it. And that happened. One of the parties challenged it, saying that this is not enforceable. And the Mexican Supreme Court upheld it, stating that the parties are free to select the procedure of the arbitration, and it falls within that procedure. And therefore, you have an enforceable arbitration award out of a decentralized arbitration. But there are limitations, and I will just take 30 seconds to speak about a couple of limitations, and probably that would give you some time to think about what those typical limitations are. The first one is, in certain these decentralized platforms, there is no seat of arbitration. They don't specify the seat of arbitration. And as we know, under the New York Convention or unsettled model law, we need a seat of arbitration unless and until a court overlooks it. So that's one thing, because these arbitrators or jurors could be sitting anywhere. We don't know their identity. And in their rules, there is no mention of the seat. So that's the first thing. The second is, some of these platforms don't give you reasoning of the arbitration award. It's mostly yes or no answer. So that could be challenging as well. And the third is, another problem that could arise is because of the lack of adoption of these decentralized mechanism by the arbitration institutes and the local courts, and their understanding of it, to what extent they can enforce. And that is also going to be challenging. We have seen some development, like GEMS Arbitration Institute released draft regulations for the resolution of smart contracts, and is still in draft till yesterday when I checked it, but probably we'll see some improvement. But these are the challenges that we are seeing. But having said that, these three platforms have collectively resolved hundreds of disputes so far of millions of dollars. And there are still people who are willing to invest and look into these kind of mechanisms. Obviously, it's not something that is suitable for all kind of disputes, but there are disputes which will highly benefit, and because of the cost, time, and the simplicity of it.
Thanks so much, Sandeep. I certainly found that whistle-stop tour of ODR and decentralized arbitration really interesting. And I'm sure others will have questions which they can either pop in the chat, or I'm sure reach out to you directly to discuss. Last but not least for today, and aptly, given that this is a CIArb webinar, the Chartered Institute of Arbitrators, Lewis, has developed new and innovative schemes to help provide alternative dispute resolution processes where a full and obviously potentially costly arbitration isn't necessarily the best option. As Irina mentioned at the start, one of those is the business arbitration scheme. Can you tell us a little bit about BAS and how it works?
Yes, certainly. Thank you, Samantha. And before I do, I just want to thank you and all the panelists, and indeed Amel, for bringing this webinar together. I'm delighted to be a part of it. I am going to I've got some very simple slides which I wanted to just share with everyone. So I trust that they can now be seen. So I wanted to just briefly go through and place the business arbitration scheme in some context, because the business arbitration scheme is one of the mechanisms offered by CIArb's dispute appointment service. And I wanted to explain a bit of the motivation behind that before I come to the actual characteristics of that mechanism. So as I'm sure everyone here knows, we're a global professional body with over 17,000 members across 42 branches, and our status is recognized as the gold standard for dispute resolution excellence. Also, a key part of our offering as a professional body is enabling our members to be appointed, to receive appointments. So that is through the accreditation, providing confidence to parties that people can understand and trust the professional expertise that someone with that set of post-nominals has. The purpose, and I think it is worthwhile just referring back to this, because again, this is where the business arbitration scheme emerged from. It's detailed in our Royal Charter, and that is to promote and facilitate worldwide the determination of disputes by arbitration and alternative means of private dispute resolution other than resolution by the court. Now, that facilitate purpose there, I think, is really at the core of the dispute appointment service. This is how we actually, in very practical terms, encourage the use of arbitration, mediation, adjudication, and other mechanisms as well. So there's numerous ways in which we fulfill that charter purpose. We influence policy as the voice of ADR, and as Director of Policy and External Affairs, it's a core part of my role. We have a public interest mandate. We're not a trade body to act on behalf of our members. We produce thought leadership, professional guidance, and so on. But as I say, I highlight the dispute appointment service as a means of achieving that. Now, to explain how the dispute appointment service works, we operate presidential panels, maintaining those across arbitration, mediation, and adjudication. Anyone who applies for a presidential appointment, they fill out the application form. It caters for all levels of disputes. And the appointment of the arbitrator or dispute resolver is made by the president from a shortlist that's generated by the DAS team. We also have some bespoke schemes which operate in a number of different areas. Most recently, we were awarded the contract to be the arbitration referral service for the Pubs Code adjudicator here in the UK. And there are other schemes that we operate as well in specific sectors. Now, the business arbitration scheme is really at the heart of this, and it was introduced a number of years ago in recognition of the fact that SMEs were in some ways locked out of arbitration as a way of, as a mechanism for resolving their disputes. There was some research which indicated that small and medium-sized enterprises in particular were either completely unaware of arbitration as a concept, as a way of resolving their disputes, or if they were aware, it was very much felt that that was for big multi-million, multi-billion pound international disputes and really wasn't relevant for them. I think there was also a sense in that research, some indications that SMEs felt that arbitration had come to emulate the court process too closely. So it wasn't particularly swift. In the words of this webinar, it wasn't early or quickly that disputes were resolved. The only real difference from the court system that people could perceive was that it was confidential, which is obviously a benefit, but didn't really apply to people who were looking for a quick and affordable way of resolving their dispute. So the business arbitration scheme was introduced to be a simple, low-cost method for resolving lower value disputes. It was particularly designed to be quick. In terms of some of the main characteristics here, I will share in the chat in a moment actually a link to the area of the CIArb website where this can be found. But BAS is designed for claims between £5,000 and £100,000. The disputes are resolved in accordance with our business arbitration scheme rules, which again can be found on the website. The mechanism offers a legally binding decision in less than 90 days from when the arbitrator is appointed. So we maintain a panel of around 250 BAS panelists. At the moment, this operates only in the UK, but I know that's something that we can come to shortly, Samantha. We do have members on that panel who are from other branches around the world as well. so that we've got that, because in some instances, even if it's a UK-based dispute, people may need expertise from elsewhere. We've got a wide range of expertise on that panel, so we would select based on the specific needs and requirements of the dispute. So it has all of those advantages of typical arbitration, but it's a much quicker and more cost-controlled means of resolving the dispute. It's distinct from our cost-controlled expedited arbitration rules. I know, Athena, you gave a good overview of expedited arbitration earlier, and we do maintain a set of rules for that. But this is very distinct from that, and is specifically designed for these lower value disputes. It is designed to be documents only. The rules specify that I believe it's about 5,000 words in terms of witness statements, statements of case and so on that can be submitted by each side. Again, that's all designed to try and streamline the process and make it as simple and efficient as possible. Parties can request a hearing. If they agree to have a hearing, then that can be arranged. It does result in additional cost. And it's limited to a half-day hearing, and there are other mechanisms within the rules which try and limit that process. The fee is £1,250 plus VAT per party, and it's designed to be a process that doesn't require legal representation. Again, which is why there's an assumption, a default assumption against a hearing, and the submission of documents is meant to be it's radically simplified. Also, when the arbitrator makes the award, any costs that are awarded to the party are limited to the fee that they've paid, the application fee, plus £1,000 in terms of their costs. So that is a strong incentive again to control those costs. The advantages of the business arbitration scheme are, I think, really self-evident in terms of early and speedy resolution, provides an award in less than 90 days. Affordability, I think, is really key. That fee of £1,250 per party is low and should be relatively affordable, certainly for most of these claims. But I think just as important as that affordability is the fact that it's predictable, and the costs aren't going to suddenly run away. Parties know upfront this is the total amount that the arbitration will cost. I think it's simplified. We find that it's made and is seen as being more accessible to parties who otherwise might find arbitration a little bit daunting, or perhaps a Byzantine process. Confidentiality in line with arbitration. Typically, obviously, this process is private and enforceable. So the awards are legally binding in line with any other form of arbitration. So that's a brief overview of the business arbitration scheme and the motivations that lie behind it. I understand, Samantha, we may have some questions as well about how that might operate and how it might apply outside of the UK, which I'll be happy to discuss as well.
We certainly do, and I think that question has come up in the chat again as well. Before we get to that, I had a simple question, which is, how do you normally see parties opt into BAS, if you like? Are parties stipulating it in their contracts up front, or are they agreeing to it once a dispute has arisen? Like, how are you seeing that operate in practice?
So that's a very good question, Samantha, and I think that there is that the first answer is it's probably word of mouth. It isn't something that is written into contracts at scale, although we may be starting to see that change. We do have a model clause alongside our other model clauses so that parties can include the business arbitration scheme there, and I think in the long run that's something that we would like to see proliferated, because that's actually how you start to see these scale of disputes come in at scale. I think the other aspect here, and it's something that we're trying to do more of in the UK, and if this was to be scaled elsewhere, it would be through the branch networks. So unlike our presidential appointment service, appointments under BAS are made by the chair of the branch in which the application was made, and I think that local knowledge, if you will, of the branch chair enables the selection of an arbitrator who is perhaps best suited to that dispute. I think in terms of the promotion of the service as well, it lends itself quite well to being promoted through business networks, through local chambers of commerce, and that is one of the avenues, I think, in which we want to do more promotion to try and increase take-up as well.
Yeah, I think a related question that had also come through the chat was how it would work in a construction disputes context. So I appreciate you've just covered how parties normally get into BAS, but are you seeing it being used in any particular industry, or have you seen it being used in the construction industry?
I don't think we've. It certainly could. There's no reason why it shouldn't operate, providing that the dispute was eligible and the parties agreed to it. Why it couldn't work for construction disputes. In the UK, obviously we have a certainly a very thriving adjudication appointment service, and that is certainly key. I think in terms of other areas where this might lend itself, we do see quite a wide range of cases come through. We've seen, in particular, the business arbitration scheme rules have in fact been used for student loan disputes in some instances. Other sectors where it might lend itself could be sort of IT contract disputes at a relatively low level. For SMEs, the amount in dispute would often fall within that £5,000 or £100,000 category. In terms of how that would apply elsewhere in the world, again, I think the way in which BAS will really take off at scale will be if parties, if branch members of CIArb, with the understanding of their local context, could perhaps identify gaps and opportunities where there would be a particular appetite for this kind of scheme.
Can I take like a step further and ask, like, is that something that is in the works? Is there a plan to look at how it might operate in different jurisdictions? And I ask from the UAE perspective in particular, because I know at conferences now over the last at least 2 or 3 years, the fact that we don't have a statutory adjudication regime keeps being raised over and over and over again. And it seems to me that for those who may want to use that kind of regime, this may be somewhat of an alternative type of avenue, maybe.
Certainly, I think what I am looking into, and the team and I are exploring this in discussions with a number of branches. I think there are almost 2 tracks to this. So within the UK, we're looking to use the UK branch network to promote the existing scheme, the one that's actually administered and overseen by the DAS team based in London, to try and increase uptake of that. As I say, it's certainly a proven concept. We've seen a good number of cases through, but there's a lot of scope for growth. The second strand, I think, would be to explore with other branches around the world about how they may adapt and apply the BAS model within their context, and perhaps have something that would be run by the branch themselves. As people here will know, no doubt, that in addition to the dispute appointment service, many CIArb branches have dispute appointment schemes that they operate themselves. They maintain panels, and that would perhaps be the the avenue through which there'd be the greatest scope for growth of this, because as I say, it enables it, firstly, administratively, it makes more sense, and there's the capacity for branches to do that. But more fundamentally, I think there's an understanding of the local and regional context and where this could really add value.
Great. It's one thing we will eagerly look out for, I'm sure, in particular in the UAE. Without wishing to push my luck on the time, before we hand over to Zaina for the closing remarks, I have one other burning question just on BAS. What is the criteria for becoming an arbitrator for BAS cases? And is there a process whereby people can apply or something like that?
Yes, certainly. So the criteria for becoming a business arbitration scheme arbitrator, firstly, it's only open to fellows of the Chartered Institute. It is not open to chartered arbitrators. One of the aims of the service is, as well as providing and filling a gap in the market in terms of parties to disputes themselves, was to try and create opportunities for appointments for newly qualified fellows, or what is often being termed the stranded fellows, those who have attained fellowship but perhaps are struggling to build up a portfolio of appointments. So it's closed to chartered arbitrators but open to fellows. You have to demonstrate that you've come through one of through the arbitration pathway, and also provide a CV outlining your main areas of expertise, which will obviously allow people to be shortlisted appropriately depending on the dispute in question. So they're the main criteria. Anyone with who might be interested in that, I will share the DAS email address in the chat shortly, and you can contact us there.
Excellent. Thanks so much, Lewis. From my perspective, that brings us to the end of the panel session for today. Thank you very much from myself to all the panel members and to the participants as well, especially those who contributed in the chat. I'll hand over now for closing remarks to Dr. Zaina Obaid, who is a partner at Obaid and Partners in the arbitration department, where she practices as counsel and arbitrator. She is importantly a fellow of CIArb and the events coordinator for the UAE branch.
Thank you very much, Samantha. I'm delighted to provide the closing remarks of this very interesting session with distinguished speakers who address the ins and outs of strategies and tools for achieving early and speedy dispute resolution. I will address in a few minutes the key takeaways of today's session in light of the recent developments that the world is facing. With the global COVID-19 pandemic, the increase in petrol prices, and the war in Ukraine, the world is facing multiple crises that are all factors in the wide-felt economic crisis. The number of disputes will therefore inevitably increase. It is very likely that smaller amounts and also larger amounts will be disputed with all concerned parties eager to settle amicably in order to limit the financial impact of the dispute and its resolution. As we have seen today, there is a wide range of dispute resolution means available, depending on the nature of the disputes, on the solvency of the parties, on the legal issues at stake, and how deteriorated the relationship between the parties is. So one ADR methods could be more suitable than another. The current practice has shown, as explained by John, that multi-tier dispute resolution clauses are becoming more popular. These clauses are indeed well liked by companies doing business internationally, and this popularity is increasing, as it's proved to be simple, quick, and relatively cost-effective form of dispute resolution compared to litigation or arbitration. In addition, companies are also increasingly comfortable with using ADR methods, particularly mediation, as a means to deal with dispute. Also, both local courts and arbitral institutions, as we have heard, seem to follow this trend and are being more active in encouraging mediation and settlement negotiations by amending their arbitration rules. Arbitrators also have an important role to play in this respect. This has been emphasized by Athena, who referred to the different tools available to an arbitrator to secure early dispute resolution. As explained by Athena, expedited proceedings is an option by most arbitral institutions today, especially for arbitration in which the amount in dispute is relatively low. In addition, early disposition of issues in dispute, widely known in common law jurisdiction, is lately making its appearance in arbitration rules as well. So these two options allow a swift resolution of disputes and match the needs of the business community for efficient and speedy dispute resolution. However, as we have heard, this might give rise to questions of due process, and arbitrators should be particularly attentive to when implementing these procedures. Now, the arbitral institutions such as the CIArb are also playing an important role by providing a dispute appointment service, thus including a business arbitration scheme, which is attractive to SMEs. As explained by Lewis, this has facilitated arbitration in a cost-effective manner for smaller disputes, while simultaneously providing appointment opportunities for newer practitioners, notably the fellow of the CIArb. So the CIArb also is planning to expand the scheme outside the UK in coordination with CIArb branches. Finally, the increase of role of technology has also impacted the dispute resolution mechanism, notably arbitration and mediation. The integration of these technologies and the introduction of new platforms has made a significant progress in decentralized arbitration. As explained by Sandeep, decentralized arbitration is emerging as a creditable form of dispute resolution where ODR failed to have a major impact. However, there are still many limitations for this form of dispute resolution to become mainstream. In addition, decentralized arbitration will also play a significant role in low-value digital and technology transaction, and in-house counsels in these fields should consider investing their time in dissecting this new subclass of dispute resolution mode. With this, I conclude my closing remark. I would like to thank you all for your attention and for attending this webinar, and we hope you enjoyed it. Thank you.